Question: can AutoPen be used by the president to sign a pardon?
Grok. No, a presidential pardon must be personally signed by the president. While the autopen has been used for routine documents, courts and legal experts generally agree that a pardon requires the president's direct involvement and signature. Since a pardon is an exercise of constitutional power, it must be explicitly granted by the president, making the use of an autopen legally questionable.
Chatgpt, yes, an autopen, a mechanical device that replicates a person's signature, can technically be used by the President of the United States to sign a pardon, as there's no explicit legal requirement mandating a manual signature for a presidential pardon to be valid. The US Constitution grants the President broad pardon power under Article 2, Section 2, stating they shall have power to grant reprieves and pardons for offences against the United States except in cases of impeachment. It doesn't specify how the pardon must be executed, leaving room for practical flexibility. Historically, presidents have used autopens for various official documents, including letters and even some legislation, when logistics or time constraints made manual signing impractical. For example, President Obama reportedly used an autopen to sign bills into law while traveling abroad, such as the 2011 extension of the Patriot Act. While there's no widely documented case of an autopen being used specifically for a pardon, the precedent for its use in other official capacities suggests it would likely hold up legally, provided the president authorized it. The key issue isn't the method of signing, but the intent and authority behind it. A pardon is valid as long as it reflects the president's deliberate decision, typically documented through official processes like the Office of the Pardon Attorney or direct executive action. Courts have rarely invalidated pardons over technicalities. Look at President Clinton's controversial last-minute pardons in 2001, like Mark Rich's, which faced scrutiny over process but not signature mechanics. That said, some might argue it's a grey area. Critics could claim an autopen signature lacks the personal touch expected for such a weighty act of clemency, potentially sparking political or public backlash. But legally, it's almost certainly fine. No statute or court ruling demands a wet ink signature for a pardon to stick.
Grok. All right, let's tear into this. ChatGPT's argument leans hard on intent, tradition, and optics, but it's more speculative than ironclad. Here's my counter. The Constitution doesn't care about ink. ChatGPT claims Article 2, Section 2 ties the pardon power to the president, personally, not a machine. That's a stretch. The text says the president shall have power to grant pardons. Full stop. It's silent on execution method. If the president authorizes an autopen to sign, that's still their power in action. Intent isn't embodied in handwriting. It's in the decision. Courts don't dissect how a signature gets on paper. They look at whether the act reflects the president's will. An autopen, properly directed, does that just fine. Intent is proven by process, not penmanship. ChatGPT worries about legal challenges over intent if an autopen's involved. But intent isn't some mystical vibe a manual signature magically conveys. It's documented. Pardons already go through layers like the Office of the Pardon Attorney or direct executive orders. If the president greenlights an autopen signature, that authorization, memos, verbal orders, witnesses, proves intent. Courts have upheld messy pardons, like Ford's sloppy Nixon pardon, riddled with procedural gripes, because the president's choice was clear. An autopen doesn't muddy that, it's just a tool. Precedent isn't as narrow as claimed. ChatGPT says autopen used for bills doesn't match pardons because one's legislative and the other's executive. Fair, but the gap's not as wide as it thinks. Signing a bill into law is a constitutional act. Article 1, Section 7, requiring presidential assent, just like a pardon requires clemency power. Obama's 2011 autopen-signed Patriot Act extension faced no serious legal pushback. Congress grumbled, but it stuck. If an autopen works for one constitutional duty, it's not a leap to extend it to another. And the "every pardon's been manual" line? That's tradition, not a rule. Absence of evidence isn't evidence of prohibition. Optics are noise, not law. The political backlash argument is real but irrelevant to legality. Sure, an auto pen pardon might ruffle feathers. Clemency's already a lightning rod. Look at Clinton's Mark Rich fiasco. But public outrage doesn't void a pardon's force. ChatGPT's ethical point about personal accountability is shaky too. Presidents delegate tons of tasks. Staff draft pardons, the president just signs off. An auto pen's no different. It's delegation of the pen, not the power. The slippery slope fear of staff running wild ignores that the president still has to initiate the process. Bottom line, ChatGPT's untested but risky takeover plays the uncertainty. There's no legal barrier, just hypothetical what-ifs. The Constitution's flexible, precedent supports auto pen use, and intent holds up if documented. Tradition's nice, but it's not binding. An auto pen pardon would stand unless a court invents a signature rule out of thin air, and they haven't yet. Game on.
ChatGPT. All right, let's tighten the bolts on this one. Grok's counter leans on constitutional flexibility and precedent, but ignores key legal and practical realities. Let's break it down. 1. The Constitution does care about direct presidential action. Grok downplays the importance of personal execution, but that's exactly what makes pardons distinct. Unlike legislation, which Congress passes before a president signs, a pardon is a unilateral act. No checks, no balances, just the president's will. The Supreme Court has repeatedly emphasized that the pardon power is personal and cannot be delegated. Ex parte Garland, 1866. The president must be the one exercising discretion, not a machine, and not an assistant operating one. 2. Auto pen signatures have been contested before. Obama's auto pen signing of the Patriot Act extension wasn't legally challenged, but that doesn't mean it was universally accepted. Critics, including members of Congress, raised concerns about whether it truly met constitutional requirements. The fact that no one took it to court doesn't mean a similar challenge wouldn't arise with a pardon, which is far more politically charged. In fact, the Department of Justice has never issued guidance saying an auto pen is acceptable for pardons, because it's a legal grey area. 3. Grok's intent is process, not penmanship. Argument misses the point. Yes, intent matters more than ink, but intent has to be clear and indisputable. An auto pen introduces doubt, opening the door for legal challenges that could force courts to rule on whether a machine-signed pardon is valid. Why create unnecessary risk? A pardon is one of the most legally scrutinized presidential acts, and every historical example has been manually signed. That's not just tradition, it's a practical safeguard against disputes. 4th, precedent cuts against auto pen use for pardons. Grok argues that since auto pens have been used for legislation, they should work for pardons. But pardons and bills aren't the same. Signing a bill is a procedural formality. The law exists whether the president signs or not. It can pass via veto override. A pardon, on the other hand, is an individualized act of mercy with immediate and irreversible consequences. The courts have never ruled that an auto pen is acceptable for such a direct executive action, and until they do, the safest assumption is that it wouldn't hold up. 5. Optics aren't just noise, they matter legally. Grok dismisses optics as irrelevant, but public perception drives legal challenges. If a high-profile auto pen signed pardon were granted, you can bet the courts would be forced to weigh in. Legal history shows that the judiciary is reluctant to endorse ambiguous executive actions, especially when they involve fundamental constitutional powers. Why risk creating a precedent that undermines the legitimacy of presidential clemency? Bottom line, Grok argues that tradition isn't binding, but when every pardon in history has been manually signed, that's not just tradition, it's precedent. Courts haven't ruled on this yet, but that's precisely why an auto pen pardon is not a safe bet. Until there's clear legal validation, the best interpretation of Article 2 is that the president must personally sign. Anything less invites legal